My name is Tarhani Fadi Alimuddin, and I will be the first presenter for the Group 1 report. So these are the topics assigned to Group 1, and this will also be the flow of our discussion in this video report. So for the first part, I will be discussing to you logic as applied to the study of law. So before we go further to the main topic of this discussion, let us first define what is logic. So logic is the study of principles and methods of good reasoning. So basically, this is a science of reasoning which aims to determine and lay down the criteria of good and bad reasoning. So through applying logic, one will be able to distinguish incorrect or bad reasoning from good or correct reasoning. So by correct reasoning, we mean here those statements or arguments which warrant the conclusion to be true, probably true, or at least plausible. So it is by means of logic that we clarify our ideas, assess the acceptability of claims and beliefs we encounter, defend and justify our assertions and statements, and make rational and sound decisions. So primarily, logic makes clear the criteria that we can use in deciding whether a particular conclusion follows from given set of principles so as to arrive at a rational and sound decisions. So logic is the study of how we ought to reason if our goal is to discover the truth. In other words, logic is the science which directs our mental operations in the discovery and proof of truth. So basically, logic differs from psychology. Logic prescribes how we ought to reason, whereas psychology is primarily concerned with how people reason. So logic is not directly concerned in describing how people do reason in their everyday activities. It does not contain rules in accordance with which man thinks, but the rules for how man ought to think. So this is for this reason that logic provides rules for correct thinking and consequently distinguishes good from bad arguments. So for the next part, let's take a look how logic relates to law. So it is stated here that law plays a vital importance to society. So the mere fact that law is part of society makes logic particularly relevant to the law. So since law has social objectives and social effects like promoting justice and stability, it must be understood by those affected by it, specifically the people who are affected by it in both in private and public aspect. So the application of law must be explained and justified. So hence the importance of clarity of meaning and soundness of reasoning and the importance of logic for the law and for legal application. So the influence of logic upon law arises from one fundamental fact, that laws are not self-applicable. We have to remember that law is not just a body of rules, but it also consists of institutions for creating, as executed by the legislators, for applying, as executed by judges and administrators, and also for enforcing, as performed by police and administrators of these rules. Legal norms do not exist in isolation, but as elements of legal systems where different kinds of norms exist. These norms directly govern the individual behavior. They establish permissions, prohibitions, or rights, and the like. It appears that different kinds of agents perform different functions are engaged in legal reasoning. So briefly then, the function of logic and the connection with the law is to secure an efficient application of legal principles by these agents. So logic, being the science of correct and sound reasoning, is indispensable in the field of law. It is actually said that logic is the lifeblood of law. The work of lawyers primarily involves reasoning and urging. In the practice of their profession, lawyers consistently use arguments both verbally and in writing. So arguments require logic to be clear and acceptable to the judges or the jury. So consequently, this is where the study of logic plays an important role. Furthermore, Without promising to guard us infallibly from error, logic familiarizes us with the rules and canons to which right reasoning processes conform, and with the hidden fallacies and pitfalls to which such processes are commonly exposed. The original use of logic in law was for the representation of law in a clear and unambiguous manner. Practitioner of law can well benefit from the processing and understanding the principles of logic as regularly used in legal reasoning and judicial decision making. So basically, the science of logic relates to the law of profession through this legal reasoning. So the efficiency of practicing law depends actually on the quality of legal reasoning. So what is meant by legal reasoning? So this comprises different methods that lawyers use to apply laws to facts in order to answer a legal questions. So basically, legal reasoning are methods by which the lawyers invent arguments from which judges or regulators make legal decisions and by which students and professionals learn law. Basically, legal reasoning is what we use when we apply laws, rules, and regulations to a particular facts and cases. It is what we use when we interpret constitutions, statutes, or when we balance fundamental principles and policies, and even when we evaluate evidence and make judgment to render decisions. So there are instances actually when, for example, a legal rule is subject to multiple interpretations. So when the legal rule becomes ambiguous, lawyers make use of this legal reasoning to argue for the interpretation that they find more convincing and favorable to their client. So it is said that lawyers become more persuasive and convincing if they develop the habit of speaking in arguments. So we have to remember that a judge or a lawyer cannot merely render an opinion on an issue and stop there. He must articulate a legitimate reason or a justification why he has ruled in such a manner. So he has actually a wide or a variety of resources to rely when deciding or when rendering his opinion. So, like the statutes, the constitution, provisions of laws, or even previous case law or legal principles and the like. So, briefly then, the function of legal reasoning and the connection with law is to secure an efficient application of these legal principles. So by examining and evaluating the elements and structures of legal reasoning, our legal judgments and decision will shift from mere subjective preference to objective rationale. So such kind of judgment and decision can better serve the rule of law. So as we all know, the rule of law rests on the quality of legal reasoning. So it requires that similar cases should be decided similarly, that each case should be decided on its merits, and that decision-making processes should comply with the applicable rules of procedures and evidence. Making the reasoning behind such decision-making transparent and open to scrutiny shifts the decision away from mere subjective preference and toward an objective rationale. It should be emphasized that we, law students, are in law school not only for learning about laws, but also to gain skill in applying the same on a given situation. So given the importance of logic in making legal reasoning, one should be equipped with knowledge on the fundamental principles of legal reasoning. So these principles will be further discussed by my co-reporters. So that ends my report. Thank you.
Let's proceed to arguments. First, let us define what is an argument. So, an argument is a concrete expression of logical reasoning. Now, it is a process of giving reasons for believing something is true. So, there is an argument if there is a disagreement between two parties. Okay, so of course, the opposing parties voice voice their opinions. Also, it is a group of statements, one or more of which the premises are claimed to provide support for or reason to believe one of the others, which is the conclusion. So, an argument is a group of statements. What is statement? It is a sentence that is either true or false. In other words, typically a declarative sentence or a sentence component that could stand a declarative sentence. There are two kinds of argument. We have the good argument and the bad argument. First, the good argument is in which the premises really do support the conclusion. Okay, so but the bad argument, the premises claimed to support the conclusion, but actually do not. Unlike statements, many sentences cannot be said to be true or false. Like, for example, the question, proposal, suggestion, command, and exclamation. Related to the concepts of argument and statement are those of interference or preposition. So the interference can be used interchangeably with argument, while the preposition can be interchangeably used as a statement. So in interference, it is a reasoning process expressed by an argument, while preposition, it is a meaning or information content of a statement. Recognizing arguments. So not all passages contain arguments. A passage contains an argument if it purports to prove something.
Moving on, statements that make up an argument are divided into one or more premises and only one conclusion. They are simply referred to as the premise and the conclusion. Now let's define what is premise. So as shown in the presentation, it is a proposition that is used to support a claim. It is a previous statement or proposition from which another is inferred or follows as a conclusion. Premise is a statement in an argument that provides reason or support for the conclusion. There can be one or more than one premises in a single argument. Now, what is conclusion? When we say conclusion, it is the proposition supported by the premise or the premises. It is the logical result of the relationship between the premises. When we say conclusion, it is a statement in an argument that indicates of what the arguer is trying to convince the reader or the listener. So it is what the argument is trying to prove. It is very common to use a conclusion indicator to stress the part of an argument that is being argued for. So arguments can have a premise indicator or a conclusion indicator. Conclusion and premise indicators are words that are used to make clear which statements are premises and which statements are conclusions in an argument. So here's a list of the most common ones. So as shown on the presentation, conclusion indicators are therefore, wherefore, thus, hence, consequently, accordingly, and as a result. As for the premise indicators, here are the most commonly used. Because, since, supposing that, assuming that, given that. It is good to note that indicator words are not always present in arguments, so you may have conclusions that are not accompanied by indicators. Typically, if you have a conclusion indicator, then the statement to which it is attached is the conclusion. So the same is true with the premises.
Good day to everyone. I am Raizadda and I will be giving illustrations on how to identify the elements of an argument, the premise, and the conclusion. To identify the two, it would be helpful for us if we first locate and highlight the indicator words we have, the indicator words. And in this example, we have therefore, as our indicator word. Therefore is a commonly used indicator word for conclusions. Hence, we could recognize that the sentence following therefore is our conclusion, which is such evidence will not be admissible in this particular judicial investigation. Now, after locating the indicator word and the conclusion, we could now also recognize that the first two claims or sentences is our premise, which supports or justifies our conclusion. And that is that the evidence presented by the prosecution was obtained through wiretapping. However, it is unlawful for any person not being authorized by all the parties to any private communication to tap any wire or cable to secretly overhear, interrupt, or record such communication. These two claims or sentences is our premise because it justifies, or it was used by the speaker to justify his conclusion. And then for our second example, MMDA's campaign to get rid of sidewalk vendors is right. The proliferation of these sidewalk vendors slows down the movement of vehicles causing heavy traffic. We have here an example of an argument without an indicator word. And in such instances, we just have to understand that our argument is being made. In the first sentence, MMDA's campaign to get rid of sidewalk vendors is right. We could see here that the speaker is trying to assert his position. And in the second sentence, the proliferation of these sidewalk vendors slows down the movement of vehicles, causing heavy traffic. Here we could see that this second sentence was used by the speaker to support or justify his conclusion that the MMDA's campaign is right by saying that the proliferation of the sidewalk vendors slows down the movement of vehicles causing heavy traffic. Hence, we have here in the second sentence our premise and the first sentence our conclusion. Now, let's also illustrate how to distinguish an argument from an explanation. To distinguish the two, we have to determine the intent of the speaker. So we have two key questions. First, is the speaker's intent to prove or to justify that something is the case, or is the speaker's intent to explain why or how something is the case? And we have here two examples. The first one is an argument, while the second one is an explanation. They might look the same because both of them have the indicator word because. However, only the first example is an argument. Any law that prohibits people from expressing their views is unconstitutional because our Constitution guarantees the freedom of speech. Here we see that the speaker is asserting his position in the first sentence. And he supports the conclusion or his position in the first sentence by providing a legal basis or support to justify it by saying that such law is unconstitutional because our Constitution guarantees the freedom of speech. This example is an argument because the intent of the speaker here is to prove or to justify the unconstitutionality of such a law by providing support. In the second example, Hubert Webb and Company were acquitted by the Supreme Court because the court found inherent inconsistencies in the evidences provided by the prosecution. Here, the speaker is asserting his proposition in the first sentence that Hubert Webb and Company were acquitted by the Supreme Court. And the speaker here is not trying to justify this position because it is already an established fact, not subject to any controversy. Hence, he is merely explaining why or how Hubert Webb and Company were acquitted by saying that the court found inherent inconsistencies in the evidences provided by the Constitution. Therefore, this example here is an explanation and not an argument.
Assalamu alaikum wa rahmatullahi ta'ala wa barakatuhu and good day. My name is Nurilaila Abdurrahim from Group 1 and I am tasked to distinguish argument from unsupported opinion and from conditional statements. Allow me to begin with the redefinition of the word argument in accordance with how my group mates have previously provided for its definition. They have clearly highlighted that an argument is composed of two basic components, the conclusion and the premise. The conclusion refers to the statement that is being claimed to be true, while the premise refers to the statement that provides evidence or basis for the conclusion. It is to be noted that in order for a statement to be considered as an argument, it must have these two basic components, the conclusion and the premise. So, with that definition, we are going to distinguish unsupported opinion from arguments by highlighting the fact that unsupported opinion refers to the statement of belief or statement of opinion of a speaker or a writer, which is not necessarily true or false, which can also be rational or irrational. Nevertheless, they usually lack the evidence to support the claim. So, what really differentiates unsupported opinion from arguments is the absence of the premise. Let us take a look at this example. I agree with the proposed Juvenile Justice and Welfare Act being discussed at present in a bicameral conference committee of the Congress. Republic Act 9344 must be amended. The minimum age of criminal liability must be lowered from 15 to 12. So this statement is clearly an expression of opinion or belief of the speaker. The speaker stated that the RA 9344 must be amended and that the minimum age of criminal liability must be lowered from 15 to 12. What makes this statement not an argument is the fact that it does not have a premise or a supporting claim to defend the opinion or this statement. Therefore, this expression of opinion is a form of unsupported opinion. Let us take a look at this another example. I believe that the current anti-bullying campaigns aimed at today's adolescents are useless and will only create a future society that is full of memes. This statement is also an expression of belief. But the thing is, it does not have a premise to support how this belief will create a future society that is full of memes. We can compare this to another statement, which is an argument, which is a form of argument that has a conclusion and a premise. It is this statement. Anti-bullying campaigns targeting today's adolescents may create a future society that is unprepared to cope with conflict. In support of this idea, noted psychologist Peter Smith explains that while reports of bullying decrease with age, the frequency of bullying remains the same across age groups. He attributes this decline in reported bullying incidents to the fact that older victims have developed valuable coping mechanisms to help deal with bullying. So the first statement here presents the conclusion, and it is supported by the second statement that serves as a premise because it serves as an evidence or as a basis that supports or that validates this conclusion here as a valid claim or as a valid conclusion. Now, let us move into distinguishing conditional statements from arguments. Usually, in most cases, conditional statements and unsupported opinions are mistakenly considered as argument. Conditional statement, similar with argument, has also two basic components: the antecedent and the consequent, because conditional statement usually comes in an if-then clauses or phrases. Let us take a look at these examples. If the Philippines adopt a parliamentary government, then we will not elect a president anymore. The first statement, if the Philippines adopts a parliamentary government, is the antecedent here. And the second statement, beginning with the word then, we will not elect a president anymore, is considered as the consequence or the then clause. What makes conditional statement as not valid arguments or not considered as an argument is the fact that the first statement or the if statement is not necessarily being validated by the second statement. Usually, conditional statements provides an implication to what the former is trying to imply, and it is being present in the latter statement. But if we are going to compare this statement in the second statement, we will not elect a president anymore because the Philippines adopted a parliamentary government. This particular example is an example of a valid argument because in contrast with the other, the presence of the premise indicator word because is here, and that makes the second statement a validation or an evidence of the first statement. Since the Philippines has adopted a parliamentary government, then we will not elect a president anymore. We can then conclude that the premise provided here has been clearly asserted. Therefore, this particular statement is a form of argument. So to conclude, we can consider a statement to be a perfect argument or to be an argument if there is the presence of conclusion and premise that serves as the basic components or parts of an argument. If in the absence of those, particular statement cannot be considered as an argument. So I think that would be all. Thank you so much.